Hello, viewers. I want to welcome you all today to another lesson. The incident in McKinney a few days ago has inspired a legal and academic debates about the legality of deploying armed military personnel on the shores of Sierra Leone to enforce domestic laws. Now, we are going to start the conversation by looking at the roles of the police and the military. In doing so, we will unravel whether it is legally possible to employ or deploy the military to enforce domestic laws, and whether it falls within the mandates of the military to do so. But we're going to start by establishing whose function is it to police or enforce domestic law. Now, police in the states is exclusively the mandates of the police force as established in the 1991 Constitution by Section 155. And this is not only limited to the police, we also have other national security agencies like the OSD, etc. And now the principal function of the armed forces are contained in Section 165, Sub 2 of the 1991 Constitution. The principal functions of the military is to guard and secure the Republic of Sierra Leone and preserve the safety and territorial integrity of the state, to participate in its development, to guard the people's achievement, and to protect the Constitution, and not to execute or enforce domestic laws. Now, what I just read is an extract from the 1991 Constitution, Section 165. Now, although it is widely recognized that the military may intermittently be asked to support national security agencies, but it only does so in extreme circumstances where the police has proven incapable of handling the situation on the ground. That is when what is called a military aid to civil power can be invoked. Now, military aid to civil power is an old concept. It's popularly understood as a military intervention at the request of civil authorities to maintain public order, while civil authorities like the police, OSD, otherwise cannot do so. There are, however, strict set of guidelines to be followed when the military can be allowed to parade and enforce domestic laws. Now, the provisions to invoke a MACP or military aid to civil power should be guided by three criteria as provided in the ISLFA policy guidelines. Now, one of the first criteria is military aid should always be as a last resort. Now, the use of mutual aid, other agencies, and the private sector must be otherwise insufficient or unsuitable. Secondly, the civil authority lacks the required level of capability to fulfill the task, and it is unreasonable or prohibitively expensive to expect it to develop one. The third criteria is the civil authority has capability, but the need to act is urgent and it lacks readily available resources. Now, to put this more into perspective, I would like to make an analogy. How do you resolve the question of what rights does the executive have to exercise judicial functions if no law prohibits it from doing so? Now, this takes us back to a proposition that says, is what is not prohibited by law permitted? Now, the answer seems that whenever any authority exercises any power or function that is not within its mandate, as defined by statute or the Constitution, the said authority may have acted above its power, that is ultra vires, and such act may be subject to judicial review by the Supreme Court. Now this brings us to the doctrine of ultra vires. The doctrine of ultra vires is a fundamental principle in constitutional law. It states that the object of a constitution can be departed from only to the extent permitted by law. So, for example, the executive may make laws in times of public emergencies or through delegated legislation, although legislative authority is exclusively vested in Parliament. So, meaning the power of the executive to make laws in terms of public emergency is a departure, but only a departure only to the extent permitted by law, because it is a departure that is also permitted by the Constitution. Remember, I said the legislative function is exclusively within the mandates of Parliament, but there are occasions permitted by law where the executive may make laws. That is, I said, in terms of public emergencies or through delegated legislation. So it is a departure only to the extent permitted by law. Hence, if an authority does an act beyond its powers, then the said act may have some legal ramifications. Similarly, the military can be said to have acted above its legal powers by trying to enforce or execute domestic laws that falls outside its defined powers that we read few minutes ago in the 1991 Constitution. So that is why I argued that policing the state is exclusively the mandate of the police and other national security agencies. Now, a departure to an extent permitted by law would be in terms of emergencies for the military. But even so, there are strict guidelines as to when and how military aid to civil power can be invoked during such emergencies, to avoid abuse of powers. Now, the term ultra vires means beyond powers. In legal terms, it is applicable only to the acts performed in excess of the legal powers of the doer as permitted by law. Now, the principle or the doctrine of ultra vires works on an assumption that the powers of any authority, of any individual in the state, are limited in nature and therefore cannot be arbitrarily be exercised randomly or at will. Thank you once again for listening. Again, this is an academic legal debate that we wish to throw some lights on.